Welcome, and thank you for joining us today for our bumper-to-bumper coverage of 2023-2024 program, covering key trends in the manufacturer-dealer relationship, presented by Seyfarth's Automotive Franchise and Distribution Team. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A feature on WebEx. However, if your question is not answered, our presenters will follow up with you directly in the coming days. For those of you interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down as it will not be repeated and it is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees following the presentation. At this time, I'd like to turn the program over to John Skelton, co-chair of Seyfarth's Franchise and Distribution Team.
Good morning, everyone, and thank you for joining. As Andy said, my name is John Skelton. I'm the co-chair of Seyfarth's Auto Franchise Team. Today, I'm joined by several of my colleagues who are integral part of our franchise team, Sam Rowley, Catherine Moskop, Lisa Haynes, and Kat Johns. Each of them will be covering, a couple different aspects of what we think are some of the key trends and significant issues that have come up in the last year and a half. As Andy mentioned, quick housekeeping, there will be CLE credit code at the end. And of course, as we have done in the past, you do not need to be thinking about taking notes throughout the program. We will circulate the slide deck to all of the attendees. I think we've got a pretty good agenda lined up. So a couple significant decisions in the last year and a half that I think are going to lead into these topics: warranty reimbursement, EVs, dealer relationship issues, the evolving ownership models, the FTC's CARS rules, which really does change the landscape, and then last but not least, one of our favorites is incentive programs. In terms of in terms of those decisions, just want to highlight a couple of the key recent ones. The Illinois Labor Time Guide was an important decision. They dismissed the constitutional challenges, which have proven to be pretty challenging to bring, in part because there was an opportunity to recoup costs. All of that reflective of the kind of, I think, increasing importance of all things warranty reimbursement involved. And Catherine, who has been one of our experts in all things warranty reimbursement, is going to be talking about that important subject. You can see here there's a couple of 2023 decisions regarding Ford and EVs. Relates both to EVs and incentive challenges. We think that EVs are still an important part of the future. We've got a combination of government regulations, we got a combination of government enforcement, and then a lot of OEMs have all of their own EV strategies. Lisa is going to be providing some content and some discussion about the EV space. Two other decisions, Mall Chevrolet and the recent Illinois Motor Vehicle Board decision regarding DSSAs and non-renewals and the implications, I think reflect that the dealer relationship remains paramount, and there are things that folks really need to be thinking about with respect to both of those. Mall Chevrolet was an important decision, affirmed lower court ruling, and essentially, dealers can't avoid responsibility for the conduct of what goes on at their dealership. The FTC CARS rules, which Sam is going to be talking about, really reflect, I think, a little bit of a changing tide, because consumers and treating consumers appropriately is the FTC is really pushing for that. Related to that is what we have seen recently, the growing consolidation with larger dealer groups buying up dealerships, and that changes that dynamic of the relationship. And Sam's going to talk about that. And then last, incentive programs, critical, essential OEM tool, but everything is scrutinized. And so Kat is going to we'll wrap up by talking about some important trends and some of the key takeaways relating to incentive programs. So with that, I'm going to pass it off to Catherine, who's going to talk about warranty.
Thank you, John. All right, let's get in. I'd like to cover today first an update on where we are in terms of the legislative landscape with, kind of the ongoing wave of increasingly restrictive state regulations applying to warranty reimbursement. Next, we'll go over the increasing focus on warranty labor time reimbursement. Following up on that, a short discussion on some rate manipulation efforts that we've seen in dealers' warranty rate increase request submissions, and then follow that with some of the available strategies for OEMs to try to mitigate increasing warranty costs. So next slide, please. The legislative landscape. At this point, every state except Wyoming now requires retail reimbursement for warranty parts and labor. As you know, that's typically defined to exclude discounts, routine maintenance, and typically results then in a rate that's even above kind of an actual average customary retail rate. 43 states have a specific calculation mechanism, such as an average based on a repair order submission sample for calculating retail rates. And then 36 states still permit manufacturers to, in some way, challenge the reasonableness of dealers' requested rates, whether that's through a comparison to similarly situated dealers, other same line make dealers in the requesting dealer's market area, or some other comparable comparison base. An increasing number of states are expanding the categories of payment classes that require retail reimbursement beyond just base warranty to include recalls, service contracts, maintenance programs, authorized goodwill or policy repairs. So the umbrella of retail reimbursement continues to grow. And more than half of states now ban cost recovery efforts by manufacturers. Next slide. We've also seen that some of the incremental victories manufacturers have achieved, whether through litigation or otherwise, have quickly been reversed through follow-up legislative amendments. Dealers, we know, have very active lobbying shops. So I've got some examples here. In some states, what was a reasonable compensation requirement was replaced by a very strict no less than retail provision. 27 states now have provisions requiring manufacturers specifically to pay retail markups on parts that the dealer may receive at no cost or at reduced cost for warranty repairs. And that has impact, for example, on manufacturer exchange programs, which some OEMs operate, for example, for complex electronic components, where a dealer may receive a part to replace a malfunctioning electronic part that then gets sent to a third-party service center. But in the case, the dealer wouldn't be purchasing that electronic part. It would just be kind of a one-for-one exchange. So we'll have to pay attention to those specific states and how they impact the terms of your exchange programs. Some states also prohibit manufacturers from establishing different part numbers for certain parts, whether replaced under warranty or under recalls, for example. And we've also seen in some states surcharges, statewide surcharges implemented by OEMs then be met with legislative cost recovery bans. And as John alluded to, constitutional challenges have not been successful thus far. We've seen efforts in Maine, Florida, Connecticut, and now Illinois that haven't proved fruitful. Next slide. So in terms of recent legislative developments, the good news, many states over the past couple of years have introduced labor time guide bills, which I'll get into in more detail later. We actually have a fairly good track record in opposing those on the policy advocacy front. Out of the 15 bills introduced in 2023 and 2024, 3 of them passed. That's in Minnesota, Alaska, and New York. New York is still awaiting the governor's signature. The Alaska bill that passed earlier this year was just signed by that state's governor earlier this week. So that policy advocacy has been fruitful in terms of significant savings resulting from those defeated LTG bills to the tune of over $1 billion in 2023. This year, there was a LTG bill in Washington that would have taken kind of the Wisconsin labor time calculation approach that died. Currently, there's a bill in New Jersey that contains multiple provisions, including a labor time provision that looks a lot like Illinois' 1.5 multiplier, includes a cost recovery ban and some other points. It hasn't gone anywhere yet, though it does enjoy some broad support by legislators. So it's likely that there will be an amendment eventually. It's just too soon to know exactly what that will look like. There still has not been any further push in California. I believe it was back in 2022 that California tried to enact a labor time guide bill that was vetoed by the governor. And then in Massachusetts, we saw a cost recovery ban amendment that stalled as well. Next slide. So in not so great news, we've got kind of a summary of what did pass over the past year and a half. New York, as I mentioned, has implemented or enacted a labor time guide bill that's awaiting the governor's signature. Alaska similarly passed a bill that was recently signed by the governor that has both a cost recovery ban and a labor time guide provision. Delaware passed an amendment that is also currently awaiting its governor's signature that has a few different relevant provisions. It expands the scope of services for which retail rates apply. It contains one of those kind of no-cost part provisions that require retail reimbursement, and it reduces OEM's time for auditing warranty claims from a year down to about 6 months. Oklahoma had a similar multifaceted amendment that passed that included a cost recovery bar. And then back in 2023, Utah, Colorado, and Missouri also had warranty amendments that eliminated reasonableness language that allowed for reasonableness challenges by OEMs and now provide for strict retail rate calculation requirements. Next slide. So that's the update on kind of the legislative landscape, new legislation. I want to turn now to the recent shift in focus to warranty reimbursement for labor times. So labor time reimbursement has historically been based on manufacturers' labor time guides, which we know are, calculated using labor time studies that try to determine actual repair times. We also know that most dealers use third-party time guides in their retail repairs that have estimated work times that are often up to 50% or even more higher than the labor times in OEM time guides. And so if you apply those third-party time guides to warranty repairs, it increases the cost of those warranty labor reimbursement costs by 50% or more. While some dealers sought third-party labor time reimbursement even before there were statutes that specifically addressed it, we've seen many state legislatures that have considered enshrining this practice in law through labor time guide bills. As I mentioned, there are 3 states that have fully enacted labor time guide amendments: Illinois, Minnesota, and Montana. New York and Alaska legislatures just passed amendments this year. Alaska's takes effect October 27th. New York's is still awaiting governor's signature. And then in Wisconsin, they've taken a different approach. Rather than requiring reimbursement according to the specific labor time allowances in a third-party guide, Wisconsin looks at the labor rate calculation process of the actual rate, and instead of requiring the dealer's labor charges in its RO submission to be divided by the hours that it actually charged to the customer, it's divided by the lower number of hours that is allowed in the manufacturer's time guide, which results in kind of an artificially higher rate by shrinking that denominator. Next slide. So this is kind of a geographic representation of what I just explained. We've got our 3 enacted states: Montana, Minnesota, Illinois. We've got the Wisconsin labor rate calculation issue, and then we've got New York and Alaska as the to be implemented labor time guide provisions. And then Maine is actually kind of a separate issue here. It doesn't have a provision in its state dealer law that specifically requires any form of labor time payment, but a court has interpreted its general retail rate requirement as applying to the retail labor time allowances that dealers charge to their retail customers. So next slide. We've got here the actual language of each of those states' labor time provisions. I won't go through the exercise of reading all of them to you, since we've got this set of slides that will circulate. But this language reflects kind of the distinctions that we've outlined in the prior map. Next slide. So John mentioned in his introduction the Volkswagen challenge to Illinois' labor time guide amendment. As he said, VW sued the Illinois Secretary of State, the Attorney General, and the members of its Motor Vehicle Review Board, challenging the constitutionality of Illinois' labor time amendment, which effectively requires manufacturers to pay 1.5 times the labor allowance in their own time guide when reimbursing dealers for warranty repairs. So VW, brought this constitutional challenge. It alleged this is redistributive legislation that just moves money basically from the pockets of dealers, of manufacturers to dealers for no public purpose. It recounted some of the specific increased costs that manufacturers will suffer, and it talked about the lack of a legitimate legislative purpose here, that the law itself doesn't require or incentivize dealers to increase technician pay, which is one of the chief kind of goals that proponents of this law asserted. It doesn't address technicians that are employed by manufacturers that sell directly to consumers. And Illinois dealers, frankly, already enjoyed kind of significant profit margins on warranty work. The auto innovators submitted an amicus brief in support of Volkswagen's opposition to the state's motion to dismiss, that cited a number specifically showing that, across the industry, they believe that the impact of Illinois' law would cost OEMs nearly $250 million a year in Illinois. So earlier this year, in May, the court granted the defendant's motion to dismiss based on 2 key holdings. Essentially, it dismissed the due process and equal protection claims under the lenient rational basis review standard that applies to this economic legislation. They said that these amendments were rationally related to the state's legitimate interest in ensuring fair and adequate compensation for dealers and for technicians in light of the, quote, perceived disparities in bargaining powers between manufacturers and dealers. It also cited the Illinois recruitment bar, which prohibits any form of cost recovery fees or surcharges. And, you know, VW had said, look, this prevents us from recovering our costs at all in Illinois. And the defendants had actually said, no, we don't think it does. We think that it should be interpreted to allow price increases that can, you know, serve as cost recovery. And the court actually agreed with the defendants. So based on that holding, the court said that VW lacked standing to assert its Commerce Clause and Takings Clause claims, as well as its First Amendment claims. So the complaint was dismissed without prejudice. VW opted not to file an amended complaint. And just a couple weeks ago, Audi announced plans then to implement a cost recovery surcharge in Illinois in the wake of this decision. And it seems likely that VW and perhaps other OEMs will follow that. So next slide. I'll move through this one pretty quickly. The next topic that we just wanted to cover briefly was the appearance of apparent rate manipulation efforts by some dealer groups that some of our OEM clients have seen in dealers' rate increase request submissions. We've seen dealers that are manipulating their rate calculations by effectively, we've got kind of this example calculation, but effectively maintaining the same retail labor charges. So that's the $300 in the numerator, but then reducing the labor times that they're charging on their retail ROs by up to 50%. So instead of, in this example, charging the customer 2 hours for a $300 charge, they're only charging the customer for 1 hour, but still keeping the ultimate total charge at $300. And as you can see, this is just kind of a blatant manipulation of the rate. Some dealers have even claimed that they're now actually using the manufacturer's time guide to bill their retail clients instead of their third-party time guides. But that kind of flies in the face of the inconvenient fact that they're keeping their total dollar amounts charged the exact same. Next slide. So this is, a little bit more detail about a couple of the examples that we've seen of this. I think the relevant point from this slide is that only one of these examples has actually gone to a hearing thus far. This was before the California New Motor Vehicle Board. The Putnam Dealer Group, used this practice with all of its OEM brands that it carries, and Ford and Kia took them to a hearing on it by, pushing back against the rate that they had requested. And the New Motor Vehicle Board in California essentially held that Ford had correctly rejected Putnam's rate request, which came in at $436 an hour, as materially inaccurate, just because of the many, many kind of discrepancies and calculation issues that appeared in their submission. And the board didn't actually reach the question of whether, under California law, the hours that generate a dealer's labor charges in its repair orders, whether that means the actual hours that a technician worked, whether it means the sold hours that the dealer charged the customer, or whether it can be some other arbitrary number that the dealer just kind of assigns. Next slide. I think it skipped. Can we back up? There we go. Quickly, this is just an example of affirmative litigation that was brought by a manufacturer. And what I found to be the interesting holding in this case, this is one where FCA had issued a notice of termination to a dealer after discovering thousands of fraudulent warranty and recall claims that the dealer had submitted. The dealer actually initiated the action in state court seeking a preliminary injunction against the termination. FCA then removed to federal court and filed counterclaims for, unfair competition, both under the general statute and Massachusetts dealer law statute that defines unfair competition, And it also brought a litany of common law claims, conversion, fraud, unjust enrichment, and breach of contract. And the important holding from the federal court is essentially that the Massachusetts dealer statute doesn't preempt the franchisor's common law claims against the dealer where it committed warranty fraud. The dealer tried to argue that the only available remedy was under the dealer statute and its, anti-termination provisions, and the court kind of brushed that aside. It also allowed FCA to bring its damages claim under the dealer statute itself without having gone through the process of, the warranty audit and chargeback process required under the statute. So, next slide. This is a little bit of an older case from 2023 involving a claim that Volvo dealers brought related to compensation, seeking compensation at their retail rates under Volvo's maintenance plan. I'll let you, review the slide separately, but essentially the court entered summary judgment in Volvo Car USA's favor, saying that it's the parties that run the maintenance plan and repair financing can't be understood to be manufacturers under the state dealer statute. And that's now on appeal before the First Circuit. Next slide. So just to sum up quickly, these warranty statutes obviously bring a lot of challenges for manufacturers and significantly increased costs. Here we've outlined various options for dealers for OEMs to try to push back or otherwise mitigate their warranty reimbursement costs. They run the gamut from, taking rigorous verification efforts at the rate request submission stage, conducting reasonableness checks, etc., making use of post submission rate verification audits that are permitted under several state statutes, implementing cost recovery surcharges, and then, taking some more kind of business considerations, evaluating the cost benefit of certain voluntary programs that could potentially offset costs, and looking at the terms of kind of voluntary warranty programs, or maybe reimbursement coverage that currently exceeds statutory requirements, whether it's worth reining that in a little bit. So that sums up my warranty reimbursement presentation, and I'll kick it now, I believe, to Lisa Haynes to cover EVs.
Thanks, Catherine. So a few years ago, the automotive industry was in what some framed as an EV euphoria, high expectations amid a government push. But as we've seen, the EV wave has had its ups and downs, and OEMs have been facing those hurdles in different ways. Next slide. So here's the high-level trends, and these will be what I'll be going over. So first is the Biden administration, who's been heavily promoting EVs. So we'll walk through how that administration's been doing that. No surprise, because in terms of media coverage, presidential election's coming. So certainly if Trump were to win, that would change that course. So we'll walk through kind of Trump's response to all of this as well. Sales of EVs have been rising globally. But that's not to say that some OEMs haven't been realizing that their expectations on EV targets have been off, or that their expansion plans, building facilities, things need to be pushed back. So we'll walk through how those OEMs have been handling that. So failure of the OEMs to meet their projected sales is driving them to rethink their retail models and think about their ICE contingency plans, where they may not have thought that they needed those a few years back. And then also, in terms of the rapid pace of market growth, OEMs are looking around to consider consolidation with other OEMs, or also just collaborating amongst themselves, either for particular technology or for creating models together as a way to kind of hit the EV market in a more efficient way. Next slide. So this is an overview of the regulatory push that's been going on through the Biden administration. They started out in 2021 with a very large goal of half of new vehicles being sold by 2030 needing to be electric or hybrids. And that goal certainly sent waves through the industry. So it's not just talking the talk in terms of the goals. The Biden administration has then enacted several laws that have been to motivate that goal and make it more likely to happen. The first one, 2021, was the infrastructure law. This was more, the purpose of it was to boost manufacturing as well as the charging networks. So you can see there the list of amounts that were going to these various categories, and the Department of Transportation has approved plans from all 50 states to build a national charging network, which of course is critical if we're going to be encouraging consumers to be purchasing electric. Second is 2022 Inflation Reduction Act. So this is more consumer based. So how do we motivate consumers that are facing a higher electric vehicle cost to purchase? So giving them tax credits on new and used EVs to up the consumer demand there. And then just this year, the EPA tailpipe emissions rule. So this is considered the strongest ever pollution standards for cars and light trucks. And so again, we have a focus on increasing EV sales and then cutting carbon emissions from ICE vehicles. So that's the federal reaction. And then similar to that, California and now 12 other states are also requiring a goal for the time frame of 2030 to 2035 of having all new vehicles sold to be EVs. And then in terms of the presidential election, obviously you can see above the Biden administration and likely to be the Harris administration as well in terms of the promotion of EVs. Trump has made the statement that he would end the electric vehicle mandate if he wins office. Obviously, he has a connection to Elon Musk at this point, so what that means in terms of Tesla will be interesting. But in terms of the, certainly he, I think, would be looking to cut any kind of consumer tax credits and a lot of the investment into the manufacturing, which would have a significant impact on OEMs' abilities to produce EVs and also the consumer demand in terms of whether these EVs are even going to be able to sell. Next slide. So let's talk first about the OEM response in terms of their goals and timelines based on these acts and targets that the Biden administration has put into place. So initially, I think OEMs were very optimistic and in terms of their sales forecasts and targets. But so you've got three big factors that have altered these OEMs' expectations. Consumer demand, and again, this is coming from I think a price issue, right? So consumers are scared off by the extent of the price, as well as the second point, lack of charging infrastructure. That's also affecting consumer demand. Where am I going to be able to charge my vehicle, beyond my house? And the infrastructure just isn't there yet. And because of the lag of that, I think consumers have been scared off in that aspect as well. And then just generally economic factors in terms of being able to up its infrastructure, the dealer element. So just in general, OEMs have, I think, had to temper their expectations. And so it's just the revolution, as we thought would be coming, is just happening slower than many of us would have thought a few years ago. So these bullet points the first two are just examples of specific dealers in terms of what's been reported of their scaling back. So you've got Ford, GM, Mercedes, Volkswagen, Jaguar scaling back or delaying their vehicle plans. So you've got GM and Ford recently paused working on a new EV factories. Ford postponed $12 billion in EV investment, and Honda abandoned a $5 billion plan to make affordable EVs with GM. But then that's not to say that all OEMs are responding in that way. Toyota seems to remain in expansion mode. It's investing $8 billion in its North Carolina battery plant and another $11 billion in research and development. Nissan also announced a goal of 40 to 60% of its portfolio comprising EVs by 2026 to 2030. So again, just difference of OEMs and how they're kind of presenting to the public of what their goals are and what they're trying to hit. Another point on the last bullet point here is that in 2024, a coalition of 5,000 dealerships sent a letter to President Biden urging them to hit the brakes on the EV push as being unrealistic for consumer demand. Because again, because of the lack of infrastructure and the pricing, I think consumer demand hasn't been where dealers thought it would be either. And so everyone's getting very nervous about 2030 coming sooner rather than later in terms of these goals. So both OEMs and dealers themselves are starting to feel nervous of how are we going to hit this. So then as you have the EVs growing more slowly, one reaction by some of these OEMs is to focus on hybrids. So hybrids can kind of be a middle point, right? You can focus on the emission standards, but costs can be down. And also the infrastructure is there as well. So there's just kind of one option for that. You have Toyota, Mazda, and Subaru have also joined to invest in alternative fuels for ICE vehicles. So if they can take the infrastructure they have for ICE, but then work it into the emission standards that Biden is requiring, then that might be a good alternative. And then lastly, we've talked about the infrastructure for charging. 7 OEMs have come together to collaborate and create a 30,000 high-powered EV chargers along major highways, which would be the largest in the country. And again, working together to benefit themselves and the general public of a way that we can actually pull this off in terms of the infrastructure. Next slide. Okay, so here's the OEM implications in the next 3 to 5 years. So, despite these falling expectations, EVs are still growing. And as this is faster than any other segment in the US, and it's on track to surpass 1 million annually. So it's certainly coming. It's just maybe not as fast as we all expected. Here's some interesting survey. Kerrigan Advisors did an OEM survey. It's about 110 OEMs. 81% of executives believe the transition to EVs will be slower. And again, this makes sense. That's kind of the overarching feeling, I think, in the industry. 64% don't expect to meet their goals, but that's leading 86% to have contingency ICE production plans. So again, that I think we thought originally the focus would really just fully shift to EVs, but that's clearly not going to be the case. And then lastly, I thought this was interesting as well. 18% said that they projected to increase facility requirements over the next 5 years, but 60% think that they'll remain the same and 22% anticipate a decline. And actually compared to the prior year, fewer OEMs anticipate an increase in facility requirements. And obviously that's, from the dealer perspective, a very important statistic of what they're going to be needing to require to do. And it seems like over time, OEMs are actually downgrading what they expect to be required of their dealers in terms of an upgraded facility. So then, as I mentioned earlier, collaboration and consolidation has become a big point then of how are these OEMs going to meet these targets. So you've got consolidation generally to meet the financial pressures of how are we going to upgrade our kind of legacy ICE facilities and manufacturing. Subaru and Toyota have come out with a co-development of 3 electric crossovers to be released by 2026. And then Toyota, Mazda, and Subaru, they're coming together as a collaboration to develop new engines for ICE cars. But they'll ultimately each be creating their own engines, but they're going to be collaborating on the powertrain. So kind of an interesting dynamic of how they're going to do that. I'll show in the next slide, dealers are really talking about EV incentives and free maintenance and advertising. So that's a pressure on the OEM side of how are we going to meet these dealer expectations and the pressures that they're facing. And they're going to certainly be coming to the OEM for funds and support. And then lastly, in terms of these goals by the Biden administration, I'm sure OEMs are feeling the push for the potential penalties that'll come if they can't meet these standards, which could potentially rack up to billions of dollars in fines. So there is certainly a lot on the line. Next slide. So this is the dealer implications, run in parallel with the OEM. So the first is their facility upgrades. I mean, we talked about, certainly the OEMs might have lowered expectations in terms of the facility, but there's basic things that a dealer would need to have in order to be able to support EVs. Charging stations, servicing, training, like there's just certain investment that they're going to have to make and changing the infrastructure because of the energy capacity they're going to need at their facilities. Here's an interesting one. GM required its Cadillac and Buick dealers to invest $300,000 in dealership upgrades. This quote came from the CEO of Asbury saying, if you know the world is going to be electric, you don't need stores to be as big as they are, maybe a small showroom and smaller service centers in more locations. So again, like maybe potentially OEMs or dealers themselves will push to have smaller facilities. But again, that's a big change in terms of what the facility looks like. And then, so this is on floor plan financing. So EVs notoriously sell slower than ICE vehicles. So just in terms of that additional cost on the dealer's front of having those vehicles sit longer in their facilities than would be an ICE vehicle. The next is based on investment and infrastructure, some dealers have just backed out. I think this has been in the news. 1,000 Buick dealerships, which is 47% of the network, accepted buyouts from GM because they didn't want to sell EVs. Half of Ford dealers opted to continue selling hybrid and ICE vehicles exclusively in 2024. And both Ford and GM have mandated substantial investments in charging station and other upgrades. So certainly there's going to be some dealers that just bow out of this given the infrastructure and cost. So here's just two surveys on the dealer side I think are interesting in terms of dealer perspective of all of this. The first is the CDK Global Survey of 250 dealers. 65% are pessimistic about the future of EVs positively impacting their business. And again, you can kind of see why. Consumer demand isn't what we thought, and the infrastructure and facility requirements needed are very high. And the next point is they're facing challenges in terms of adapting all these technologies. And then 80% of them represent brands that sell EVs, but only 59 have actually begun transitioning their operations. And again, that's reflected too in the point above about how many have backed out when given the option to sell EVs. And this last study, Cox Automotive did 526 dealer study. And then this one is, even though they've shown that they're finding that OEMs are supporting them more in marketing, sales, and service, their focus is on incentives and advertising and maintenance assistance, because again, EVs are more expensive and have lower margins potentially for the dealers. And so they're really going to be pushing for the money come to their profit line through some way, and they're going to be pushing for incentives, and the OEMs are going to feel that pressure. Dealers feeling urgency to sell. 65% of dealers are feeling pressure from their automakers to hit targets. And then lastly, 86% said they're likely or somewhat likely to continue making EV investments required by automakers, which is a good, I mean, that's a high percentage. Next slide. Okay, so will this lead to alternative distribution models? So here's the current distribution models. We've got traditional, direct to consumer, and hybrid. Now, we're all aware that state laws are are what's restricting legacy OEMs from being able to bypass their dealerships and do direct to consumer sales. In the Kerrigan OEM survey on this point of kind of what is their distribution model is going to look like, 57% did not expect the agency model to be introduced in the United States in the next 5 years. And again, a lot of that is driven by challenges on the dealer side and just how strict these laws are, driven by the dealer lobby. So as EV inventories rise, OEMs such as Ford are abandoning their plans to take a more active role in retailing, and many are recognizing that the dealer network as it exists now may actually be more efficient. So I think when this all EVs first came out, we thought maybe this would be it and a true shift, but maybe not. And then while OEMs are more supportive of legacy sales, a rising number expect to take a leading role in the consumer relationship. And so below, you can kind of see examples of how they might be trying to do that. So Toyota's expressed a commitment to the traditional dealership model, but it's still seeing extensive dealer network as a competitive advantage. You'll also see some of these dealers have tried to do an agency model in Europe where it's permitted and have pulled out and decided not to. And then most interestingly, I think, is in 2024, Hyundai is commencing a Amazon retail program. And through that, customers can just buy on Amazon. And that's going to be a lot more direct involvement with Hyundai. And so we'll kind of see where that goes in terms of the future. So I'm going to hand off to Sam Rowley, who'll be talking about the ownership model for OEMs.
Sam, you're on mute.
Sorry about that. So we wanted to spend a few moments on, on the evolving consolidation in the, among dealers in the industry, and what does that mean for OEMs and their relationships with their dealers. Let's go to the next slide, Andy. The traditional, as we all know, the traditional sort of ownership model for, the first several decades of the industry has been the mom and pop dealership, the family-owned business, maybe a small company that owns one, two, maybe three dealers. And really over the last sort of couple of decades, the model has begun to change, where a substantial portion of the industry, now consists of public companies owning as many as several hundred dealerships, or you've got sort of in a middle tier privately owned companies, sometimes with private equity backing, that own dozens of dealerships. And even you're seeing some ESOP owned companies as well. And so now that it's become pretty clear that this trend of consolidation in the industry is here to stay, we thought it's important to spend a few moments sort of reflecting on what that means for OEMs and what OEMs should do about that. Let's jump to the next slide, Andy. I just touched on that one, so we can go to the next one as well. I've got a quote here from Automotive News from a couple of months ago in May. I thought this was an interesting quote because it came in the context of an article about how NADA is sort of retooling its academy for training its next generation of leaders. And it sort of really reflects this notion that, the emerging sort of leaders in the industry within dealers, many of them really haven't come of age, in the family-owned business. And so it's something that, NADA is thinking about as it sort of trains the next generation is, how does it prepare that generation of leaders in the new sort of ownership model? Next slide. Don't need to belabor the point, but despite the sort of downturn in M&A activity over 2023, the sort of pace of dealership consolidation really did continue in 2023. And next slide, Andy, shows that again in 2024, off to a pretty hot start. Automotive News just reported this month that in terms of acquisitions, we're off to a record-breaking pace in 2024. So next slide. So what does this mean for OEMs? We cover here on this slide some of the challenges, some of the questions that are raised for OEMs. Some of the big ones are, who really is in control of operations? When you've got a complex sort of ownership structure, are there investors of which the OEM's not aware who may have some sort of influence and control over management or operations? To what extent, is capital at the sort of ownership level really dedicated to individual dealerships? How do OEMs measure and how do they enforce, individual dealership performance versus performance within the entire dealership portfolio? And then what are the business objectives of the dealership group versus the OEM's business objectives? Are they at odds in any way? And then, of course, OEMs are sort of working within the confines of outdated state dealer laws that are in many ways really designed around the traditional family-owned business, by which they really do restrict or limit the ability of OEMs to reject dealer acquisitions. Next slide, Andy. So we've come up with sort of a three-pronged approach for OEMs to think about in sort of confronting what the changing ownership landscape means for its relationships with dealers. Strategy number one would be, and I'll touch on these in a little bit more detail, but strategy number one would be for OEMs to either develop or update and make sure that they publish, to their dealer body, new ownership and transfer policies and procedures. Strategy number two would be to really take a hard look at what your sort of buy-sell review process is and whether that needs to be modified in any way to reflect the changing landscape. And then strategy number three would be to consider whether it would be appropriate for the OEM to implement what we call a portfolio agreement. And I'll touch on that in a moment. Next slide, Andy. Since you're going to be left with these slides, we cover a lot of material in the next sort of half dozen slides or so, but we wanted to sort of leave you with a lot of things that you ought to be thinking about with each of these three strategies. So for strategy number one, whether you need to implement or the OEM needs to implement or update its ownership and transfer policies, we're going to leave you with a lot of things to think about here. Whether the OEM wants to limit, impose ownership limitations, how many dealerships can be controlled by one group in a particular market, region, or across the country. Whether the deficient performance of one dealership in the portfolio, should disqualify the ownership group from acquiring an additional dealership, and what should be done about that. Whether you want to require the submission of an annual business plan, that addresses both individual and portfolio performance. Whether the ROFR should require a separate dealership valuation when a multi-point dealership buy-sell is at issue. And of course, another important issue is to look at cross-collateralization in the loan documents. You don't want to default by one dealer to jeopardize the other entities. Next slide, Andy. In the second strategy, how can the OEMs maybe better manage the buy-sell process given all this consolidation? You can't reject a particular or a proposed acquisition on the basis that the buyer is a public company or a large dealer group, but there are certainly things you can do to take tighter control over the process and to make sure that the transparency is there that you need. Number one would be implement the strategy that we just talked about, and then of course make sure that your response letters in the buy-sell application process is requesting as much information as you need about the ownership structure, about the corporate entity chain, the documents, all the ownership documents that you want to review. Making clear that the entire ownership chain, including the ultimate parent, is going to have to comply with all of the OEM's policies. You want to make sure that you set up some process where you can meet with and interview the proposed owners so that you can understand what their long-term, short-term, and long-term strategic plans are. What are their plans for growth? What are their plans for the contiguous markets? Document representations and commitments that they're willing to make in the approval letter. And really just take a hard look and make sure that you, the OEM, is understanding what the buyer's overall strategy is. Next slide, Andy. I touched on a couple of these points, but again, as part of this process in bucket number two of taking a look at how you can improve your buy-sell approval process, making sure that the dealer entity is going to live up to and comply with all performance standards of each individual dealer that's in its portfolio. What do you do if the selling dealer is a poor performer? Take a look at what the buyer's track record is with turning around poor performers. And of course, what if in the buyer's entire portfolio there are some poor performing dealerships? How do you want to address that issue? And again, I touched on this earlier, but do you want to impose limits on how many dealers a particular dealership group can own or control in a market or a region or across the country? Are they putting too many eggs in one basket? Next slide, Andy. We'll leave you with this slide. So let's jump to our sort of strategy number three, and this is whether the OEM wants to consider what we call a portfolio or a framework agreement. Now, this would be a separate agreement, separate from the DSSA, that would really be between the OEM and the ultimate parent, or the holding company. And the objective of that agreement would be to address and mitigate, some of the risks that we've been talking about that are inherent in sort of these complex ownership structures, particularly with these large, portfolios. And so, we'll leave you with some of the key terms that we suggest you think about in a portfolio agreement, but some of them would be, ensuring that each of the dealer entities, will comply with all of the OEM's policies, including the ownership limit policies, laying out, what the processes and the standards are for acquisitions of additional dealerships, making sure that successor issues are addressed, requiring the annual business plan that we talked about. And so addressing ROFR rights, making sure that the OEM, that the facility image standards are going to be met by all of the entities in the ownership chain. And so you're really trying to hold the ultimate parent, to the standards that the OEM wants to hold it to in this separate sort of portfolio arrangement. And in that portfolio agreement too, you can address, one of the issues that we talked about at the beginning, which is how do you want to measure and enforce your performance standards on an individual basis versus the portfolio basis? So I'm going to switch now to the CARS rule that the FTC has introduced and touch on that just for a few minutes since we're coming to the very end. Andy, let's jump to the next slide. NADA has made clear that this CARS rule is a very big deal in the industry, and earlier in 2024, the NADA president said, it is the biggest obstacle that dealers will face in 2024. Next slide, Andy. Spoiler alert is that the rule was originally going to take effect yesterday, but it's on hold pending a challenge by NADA and the Texas Dealers Association in the Fifth Circuit. This was really a rule designed around increasing transparency by dealers to consumers in the sales process, and it's followed on the heels of a lot of enforcement activity, a lot of investigatory activity by the FTC, prompted by hundreds of thousands of consumer complaints about sort of the lack of transparency that consumers have felt in the sales process when they walk into a dealership. Next slide. Just a kind of colorful quote here from the FTC about really what the rule is intended to do is to get rid of junk fees, bait and switch tactics, false advertising, tricks and traps, as the FTC calls it. Next slide, Andy. We'll leave you with this slide, but really there are sort of four major prongs to the CARS rule. There are a lot of moving parts to it, but these are the sort of four major points. It's really to prohibit misrepresentations in the sales process, ensure that advertisements aren't false, make sure that buyers are expressly informed and giving their consent at every stage of the transaction. Next slide. This is just a sort of highlight of one of the areas that the FTC is focused is the add-on products. The FTC is really focused on making sure that consumers aren't getting sort of deceived in additional products that might be sold with the vehicle. Next slide, Andy. So bottom line is the CARS rule, while this FTC has stayed its effective date at the moment pending this challenge. The challenge is going to be argued in the Fifth Circuit in October. I think it's safe to say that the rule, if the challenge is not successful, and I think it's probably a difficult challenge to bring, the rule is probably here to stay, even if in a different administration, because the FTC has invested quite a bit of resources in bringing the rule to fruition. It's very popular among consumers, consumer advocacy groups. So two kind of things we want to leave you with just to keep an eye on. It's a little early because the rule is not yet effective. It may not become effective until next year. But on this last slide, Andy, a couple things that OEMs ought to be thinking about is whether they're going to need to either update or implement policies to ensure that their financing arms are sort of on top of dealers complying with CARS, and then taking a look again at their advertising policies to ensure that they sort of jibe with and are consistent with what CARS is imposing in terms of advertising requirements on dealers. So I'll wrap that up. We're kind of near the end here, so I'm going to turn things over real quickly to Kat to hit upon incentives at a very high level.
Thanks, Sam. Yeah, we've only got a couple of minutes. So Andy, do you mind either putting in the chat or bringing up to the screen the CLE code really quickly for everybody? Thanks so much. And then I'll just briefly talk about at a very high level where things are with incentives, which is business as usual, for better or worse. Lisa covered kind of a lot of this about EVs, which I think is the sauciest topic right now in terms of incentive programs, and it kind of remains to be seen how those are going to pan out going forward. Other than that, a kind of interesting development for those of you who've taken Civ Pro is whether coalitions will have standing to challenge some of these incentives as well. This is just my first slide, Andy. And then we're going to talk a little bit, and this is covered in the slides, so feel free to review. They are excellently crafted, just about how you can use digitization and other tools in really cool ways. But keep in mind that dealers might be able to too. So this is just something to keep an eye out as we keep chugging along. And I'll pass it back to John.
So thank you. Sorry, we got a little crunched in time. There's just so much to talk about. We did get a couple questions, and unfortunately, we don't have time to answer, but we will circle back. Again, here's the CLE code, SS2398. Scan it. Oh, wait a minute, I got that wrong. SS3344. SS3344. Again, thank you, everyone. You will get a follow-up email with the deck. There's a lot of information in there, and we'll circle back on a couple of those questions that we didn't get to. Again, thank you very much. Happy to provide this information and happy to have an opportunity to discuss. And thank you to all of my colleagues for putting in some great work.